Justice for the Serlick Children podcast.
The content of this episode is for educational and advocacy purposes only. All statements made reflect documented filings and communications received by Heather Bendel and the Justice for the Serlick Children team. We encourage all listeners to form their own conclusions based on the evidence presented. No accusations are made without supporting documentation, and all persons are presumed innocent unless proven otherwise through due process.
Good evening, everyone, and welcome to Season 2, Episode 8 of Justice for the Serlick Children podcast. Today is Sunday, April 19th, 2026, and tonight we are going to discuss everything Florida District 5 Court of Appeals in Daytona Beach, Florida, and Illinois District 2 Court of Appeals in Elgin, Illinois, since March 17th, 2026. Plus, discussing my 14-year-old daughter, Bianca Elizabeth Serlick's Volusia County Schools Quarter 3 report card, which continues to show she desperately needs help.
Yeah, and just a recap to bring everybody up to speed on how we got here with multiple appeals cases. This goes back a while. Obviously, Heather's had her family law case has been ongoing for over 6 years now. But here in Florida, there were multiple appeals filed. Those all went to the Florida 5th District Court of Appeals. And in an effort to sort of on a side track, when Florida Appeals Court was trying to say they don't have jurisdiction, Heather went back to the original court up in Illinois to figure out if they have jurisdiction, and we asked them to vacate this 3-page order that
Florida won't touch.
Yeah. So Illinois Circuit 19 refused to do that, so you filed an appeal that got into Illinois 2nd District Court of Appeal. Mm-hmm. And then really strange, if you know anything about appellate courts, somehow both of these got synced to almost to the day.
Yeah.
You got basically opinions, if you can call them that.
One day apart.
One day apart.
But what did we discuss at the end of episode 7 in regards to this motion to show cause?
So they had the Florida 5th District Court of Appeal had issued a motion to show cause, basically saying, tell us why we shouldn't sanction you and prohibit you from filing anything in this case.
Quoting criminal law, not family law.
Yeah, it was very clear whoever put this order in just copied and pasted something, clearly didn't really know what Heather's case was. So I feel like this was just a cookie cutter, cut and paste kind of thing that they're probably trying to try on multiple
pro se litigants. Absolutely.
And you called them out on it.
I did.
And their response came back.
Yeah.
Oh, sorry. It was a clerical error.
Yeah. So
it was not a clerical error. This was them trying to be sketchy as hell.
Yeah. So ironically, and I called this out. I freaking called it out, and I told you while we're on spring break in Illinois, there's going to be activity in both of my appellant cases, and boy was I right. Yeah. It is becoming increasingly obvious. I can predict exactly what they're doing.
Well, at least
and why they're doing it.
At least with the Florida case, we had a good idea because they had, right before we went on spring break, they had consolidated all of your cases into one.
I had 4 appellant cases for 4 different reasons. Each appellant case was arguing something completely separate from everything else.
And they were all based on different
case law and statutes.
And in different orders from the lower court.
Right.
So it's not like you were just reappealing multiple times the same thing.
So in episode 7, we touch on the consolidation of all 4 cases and then the affirmation of all 4 cases literally 2 weeks after, 14 days to the T after they consolidated. So they're like, ha, 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 we're going to consolidate all 4 of her cases and then affirm them, a.k.a. dismiss them all at the same time and wipe our hands of it.
Now, the ironic thing is you had actually asked them to consolidate 2 of the cases previously,
and then they turned it down.
They refused to.
So it is becoming extremely obvious
So
that these judges are all protecting each other, and they are not following the laws, and they are absolutely not protecting my minor children. And these people will eventually be held accountable for what they are doing to my children. So I'm going to read this one-page response to my response to show cause, which literally called them out on their stupidity. And so here's the response on March 17th. So this was while we were in Chicago. And the panel of judges, all three of them, by the way, were appointed by Governor DeSantis January 2023. All three of them. You can look it up on the website.
These are three very new appellate judges.
Appointed at the exact same month and year by Governor DeSantis. And the reason I'm pointing this out is because all of us in Florida that are starting to connect to each other are starting to realize that all the judges that are harming us are appointed by Governor DeSantis, which means he is going to be getting some lawsuits as well, because he is responsible for these judges since he appointed them. So not only does it touch on my response to show cause, it also touches on my motion for rehearing. So these panel of judges are Soud, S-O-U-D, Kilbane, and McClaver. I don't know if I'm pronouncing McIver, M-A-C-I-V-E-R.
McIver.
Yeah, all three of them are sitting in Daytona Beach Court of Appeals directly across the street from Daytona Circuit 7. You can literally throw a stone and it lands in the other courthouse. All of these judges play golf together, go to the same country clubs together, go to lunch together. They're all protecting each other. Daytona Beach, this is where your taxpayer money is going. So it says, notwithstanding the clerical error in the preparation of this court's order of March 6, 2026, which did not accurately reflect the understanding or concern of the court, appellant's response filed March 8, 2026, accurately disconcerted and addressed the court's concern with repetitive and meritless motions in her family law case. In that, appellant has demonstrated her understanding of the court's concern. Imagine that. I understand what's going on more than you guys do.
Yeah.
It is ordered that appellant's response is accepted, and this court's March 6, 2026 order to show cause is discharged. Additionally, it is ordered that appellant's motion for rehearing and written opinion filed March 8, 2026 is denied.
Yeah.
Why is written opinion important?
So, well, and this is one of the just absurd things about Florida appellate court system. You need a written opinion to have something to appeal to the Florida Supreme Court. Mm-hmm. The 5th District, and it's probably not just the 5th District, but it's the 5th District we're working with. The 5th District has essentially said, we're just denying your appeal. We're not going to tell you why, and we're not going to write anything down, so you can't challenge anything to the Florida Supreme Court. Mm-hmm. It's really, if you think about it, it basically destroys any system of checks and balances.
Yep.
Because there is basically the Florida appellate district, if they don't like somebody or don't like something, they can just shut it down, not issue any form of written opinion. I mean, you got a 1-page letter with the word affirmed on it.
Yep. No, nothing other than affirmed. Just affirmed on 4 different appellant cases with 4 separate and different
very distinct
appellant
issues.
briefs that I filed. And might I add, in all 4 of those, Justin didn't respond. Mm-hmm. Justin didn't do even a notice of appearance.
Didn't even contact the clerk.
Nothing.
As far as we know.
Ariana, Tommy, Bianca, and Charlie, your father is literally ignoring everything I am filing.
Yeah. So how are you supposed to get anything through if his response is just, well, if we don't respond,
that he doesn't have to respond because Mary and Ira Serlick are pulling all the marionette strings behind the scenes with their illegal connections and money under the table. I wonder how many thousands of dollars in debt they are because of their paying off backdoor things. So next, after that, this came in, and here is another clerical error by Florida District 5 Court of Appeals, putting that lovely taxpayer money to work. They filed the mandate. So on April 6th, it says, mandate from District Court of Appeals, this cause having been brought to this court by the appeal or by petition, and after due consideration, the court having issued its opinion or decision. You didn't issue any opinion. You are hereby commanded that further proceedings as may be required be had in said cause in the accordance with the ruling of this court and with the rules of procedure and laws of the state of Florida. Witness the Honorable Harvey L. J., Chief Judge of District Court of Appeal in the state of Florida, 5th District, and the seal of said court at Daytona Beach, Florida on this day. So essentially what this means, if you throw it into AI, it's literally just confirming their decision of affirming, and it's now on the record.
And it's kicking it back to the
Florida Circuit 7 Daytona, directly across the street. So that was filed by Florida District 5 Court of Appeals on April 6th. And then right after that is the stamped copy filed in Florida Circuit 7, April 6th at 8:24 a.m. Okay. So, of course, as always, you can click on the Google Doc link. If you're listening to this on audio only, there will be a Google Doc link so you can open up, view, download, save all of these court documents we're going through right now. As always, every single one of our podcast episodes do that. So you will be able to see these and save these in real time and read exactly what I am exposing. Okay, so that is the mandate. And then right behind it is the literal one-page affirmed with absolutely nothing other than affirmed for all 4 of my cases that were consolidated together.
And it really, as the outsider looking in, it is somewhat infuriating to me that knowing what goes into filing an appeal and preparing an appellate brief, and the amount of, procedures and rules you have to follow to get all of that done, for the court to be able to just turn around, send out a one-page affirmed with absolutely no explanation. No, well, we looked at your arguments A, B, and C, and while we agree that this is an issue, this is not state law. This was not an issue in this case. Supersedes it. Nothing.
Right. Absolutely
nothing. It's literally...
It's an insult and a joke.
Imagine whatever your job is out there, and you can just get out of doing any work by writing a one-page letter that just says, whatever we did yesterday was fine.
Yeah. But on this mandate, it only has my original appeal case from April of 2025. Okay, so exactly 1 year after I filed my first of 4 appeals, it's all finally said and done 1 year later. But it only has case number 5D20251056 on it. And I thought that was a little interesting because I'm opening this and I'm reading it and I'm like, they consolidated it and here's the proof that they consolidated it, but this only has the one. So, wouldn't you know...
It's like they were reading your mind.
The very next day, April 7th, 2026, there's an amended mandate that they pushed through that now has all 4 of the court cases that they consolidated. So amended and is highlighted at the top. And then the 3 cases that they didn't have on the original mandate are now highlighted behind the original case. And then, of course, there is a new file stamped with Florida Circuit 7. So it's literally the exact same thing One is a mandate, one is an amended mandate, and one has only one case on it and the other has all four. So there's another clerical error coming out of Florida District 5 Court of Appeals in Daytona, Florida.
Like, I mean, and you honestly, as the taxpaying citizen of Florida, it infuriates me because what the hell are they doing? If they can just, they've literally gotten out of doing all the work by submitting a one page. They have now sent, 2 things through with, one was a clerical error. That was the mandate. I would consider that a clerical error. The other thing was absolute,
that was intentional.
Just intentionally trying to
silence
what
me.
if you had not responded to that?
They would have silenced me.
They would have prohibited you from filing anything.
The average
in your
American
court again.
that doesn't understand legalese and rules and procedures in laws and courts and such would probably have seen that motion to show cause and never even responded because they're like, well, they're silencing me. Yeah. What else can I do? The average pro se litigant, without having AI to break it down in layman's terms, would literally ignore that motion to show cause, and they would have just literally, in the time frame that they gave, then silenced me in Florida Circuit 7, which was their intent. They're trying to silence me because they know they're wrong. They know what they're doing is illegal, and they know they are not protecting Florida children, and they're going to go straight to hell for what they're doing.
So now, as far as the Florida Appellate Court, obviously, 5th District has basically shut everything down.
Yep, that's where we're at.
You can't file an appeal to the state Supreme Court.
It is called a
But that doesn't shut you down completely.
Right. It is. So to appeal, if they had given me a written opinion, my next step in Florida would have been what's called a PLA, petition for leave to appeal to Florida Supreme Court. But without that written opinion, you cannot file a PLA. Florida Supreme Court will deny it and kick it right back and say, well, there's nothing to argue because there's no written opinion.
We have nothing to look at.
But that doesn't put up a complete roadblock. There are what's called extraordinary writs. Mm-hmm. So there's a writ of habeas corpus, there's a writ of prohibition, there's a writ of centuri, there's a writ of mandamus. There are plenty of writs that you can file. Now, traditionally, extraordinary writs are not usually granted. However, as we've been learning across the nation,
they're starting to be looked at more and more in family courts.
Are actually, especially when it comes to family court, some of these writs are actually being granted because the upper courts are recognizing
that the circuit courts are just doing things wrong and messing up families.
They're incredibly egregious.
And the appellate courts are just covering their eyes to it.
Yeah. So that's it for Florida District 5 Court of Appeals. That's all they've given me since March 17th. Now we're going to shift to Illinois District 2 Court of Appeals, and
we've got some interesting things to tell you about the Illinois 2nd District Court of Appeals. This started
literally one day later on March 18th. So Florida District 5 affirmed me on March 18th or 17th, and then March 18th, while we're still in Chicago, District 2 Court of Appeals in Elgin, Illinois, Kane County, pushes through this. So this is the decision on my, and this is a lot thicker because
it's an actual written opinion.
Unlike Florida, they are actually giving me written opinions. So all of this will, of course, be scanned. It's in one big document, so you can scroll through and follow it in real time. But the first document is from Clerk of the Court Jeffrey H. Kaplan, and he and I are he knows exactly what I plan to do next. He knows exactly what's going to happen. He knows he will be a defendant in my 42 USC 1983, 85, and 86, and he will be falling under 85 and 86. So he's going to be a defendant as well. But Jeffrey Kaplan has signed this. Decision of the court has been filed this date. The Rule 23 order will soon be posted on the Supreme Court website at illinoiscourts.gov. Okay, so he filed that, and then the order filed March 18th, 2026. Obviously, we're not going to read all of it because it's big.
But there was some stuff that just jumped out
that
was somewhat infuriating. First, they truly did not even look at your, the original petition, which actually restarted the case in Illinois, because what you filed was a petition for relief and vacatur,
right,
under a specific Illinois statute. And the appellate court basically looked at everything and said, oh, you're just trying to, file a new parenting order.
Right.
Which is not what you were doing.
It was very obvious they didn't read my appellant brief. So this was signed by Presiding Justice Kennedy, delivered the judgment of the court. Justices McLaren and Burkett confirmed in the judgment. So these are District 2 Court of Appeals judges that sit in Elgin, Illinois, in Kane County. So all three of them are going to be defendants as well in my U.S. District Court case. So on page 1, it says, held. The circuit court did not err in dismissing petitioner's pro se petition, which sought to vacate a parenting order affecting the custody of her children. A 3-page ex parte order.
But that's the other thing. They constantly refer to it as a parenting order.
It literally just says order.
It is the actual paperwork just says order.
It's not a parenting order.
There are specific rules, and this is the Supreme Court's going to see this, because there are specific requirements in the state of Illinois that have to be included in a parenting order.
Yep.
And these required elements are just flat out not in this 3-page order that has wreaked absolute havoc.
Yeah. So it says, almost a year before the petition was filed, the circuit court had relinquished jurisdiction of the petitioner's family matter to the state of Florida because at the time of relinquishment, all relevant parties had permanently resided in Florida for over a year. Thus, the trial court has a reasonable basis to dismiss the petition because Illinois was no longer the home state. Affirmed. Okay, well, so let's look at this.
Completely wrong.
Florida says they don't have jurisdiction. Illinois is now saying they don't have jurisdiction. One of them has to have jurisdiction over my children. Both states are claiming they don't have jurisdiction. So federal court, here we come. And federal court will be who decides what state has jurisdiction and when it officially started. Yeah. When it officially started for Florida is when I transferred my Illinois driver's license to the state of Florida, which was February 8th, 2022. The 3-page ex parte order was filed in Illinois April 27th, 2022.
After everybody was in Florida.
Several months after I became a Florida resident. That means they had zero jurisdiction to even sign that 3-page ex parte order. It's really that simple. There is subject matter jurisdiction, and one of the states has it and one of the states don't. Both states are saying they don't have jurisdiction.
Well, actually, they're both simultaneously saying they have jurisdiction and they don't have jurisdiction. They're really picking and
Here's
choosing
the RICO.
the small portion of things that they want or don't want. And the reality is, I mean, we thoroughly researched this statute in Illinois to base your case on.
Pause for a moment. How high of an education do you have?
Master's degree.
And I am a master's candidate about to be awarded my master's degree in less than 2 years. So we are two fairly educated human beings. So between the two of us doing research, I'm pretty sure we're capable of figuring out rules and laws and jurisdiction.
Well, and here's the thing.
We have plenty of resources and we have the brain power between the two of us.
I know we covered it in a prior podcast, but just to bring people up to speed, basically what you had filed in Illinois, the petition for relief and vacatur, was under a specific Illinois statute that says Illinois court, as the original issuing court, has jurisdiction to correct, errors that they've made, even if the jurisdiction subsequently transfers. And this is the problem with the Illinois Appellate Court. They're looking at it completely wrong. They made the same fatal error that the Illinois Circuit 19 made, where they're looking at it as a current modification, and that's not what the statute calls for, and that's not what you filed.
You're giving them too much credit. They know exactly what they're looking at.
But again, what you filed was basically saying this 3-page order that was issued back in 2022 wasn't right and wasn't valid, and it needs to be stricken from the record. What they're trying to make the argument is, well, that was signed, so there's a parenting order in place. So now anything to change that is a modification,
right?
And only the current court with current jurisdiction can modify it. But again, if the order was void and bad from the start, the legal term is void ab initio. I know you love that term.
I do.
But it basically
Lauren.
means that the order was void from the start. So it as if it was it did not exist. So if it's void from when it was written, it gets vacated. The current order, you're not modifying it. It did not exist. It does not exist.
Right.
And that's, again, it's the fatal error that Illinois Circuit 19 made. The Illinois District 2 Court of Appeal has essentially made the same error because they didn't actually read what you had argued, let alone what you had filed.
Say hello to the followers. This is Willow. My daughter Ariana named her back in 2019 when we got her. So that whole affirmation with written opinion was 11 pages. I'm not going to go through everything because it's literally 11 pages of bullshit where they're arguing case law that literally has nothing to do with my situation.
Yeah.
But Section 3, conclusion, we affirm the judgment of Circuit Court of Lake County affirmed.
Yeah.
So,
the crux of what they're saying is there was one prior Illinois Supreme Court case decision, and they're saying because of that decision, all of the rules, the statutes regarding the UCCJEA are, it's that scene from Pirates of the Caribbean. They're more like guidelines than actual rules.
right.
They're essentially, the Illinois Second District Court of Appeal is saying, we know these are statutes, but that doesn't matter because the Constitution says that the court was allowed to make a decision. So then why do we have statutes? They're literally saying, we're just going to look at this one law and let the court completely ignore all of the other laws.
Right.
And that's all because of this other prior Illinois Supreme Court case, which, I mean, it's however they got that one through because it's mind-numbing that you can say, well, the Illinois state constitution says courts in Illinois can make a decision on any matter that can be adjudicated. They have constitutional authority over. Yet the Illinois legislature passes statutes. These are laws in the state of Illinois that courts and attorneys and guardians and everybody, they're supposed to follow the rules. These statutes are in place to protect parents like Heather from due process violations.
Yep. And my whole situation the last 6 years is...
They're literally saying, we don't care about the statutes. UCCJEA doesn't matter to us.
No. We're being paid by the Serlicks to hide your children from you. And now, because there's so many people involved with the whole situation, we've got to protect each other. Yeah. Fuck the fact that my children need help. Fuck the fact that you're walking all over my constitutional rights, due process, my right to parental familials, Troxel Granville. You want me to say it again? Where's my quack? Where's my apple quack? There we go. Yeah, that's my favorite censor. Okay, so after we got that, while we were still in Chicago, as soon as we got back, we had already brainstormed on the drive home how we were going to proceed with a petition for rehearing, because that is my right. When you get a affirmation, the very next thing you file is a petition for rehearing.
And what that is basically you telling the Illinois District 2 Court of Appeal, we got your opinion on this case, but here's why you guys are wrong.
Right. And Illinois has pre-filled forms on illinoiscourts.gov .gov or whatever the website is. So you can find a petition for rehearing instructions and the rules on the website. So this is required to be filed in green, light green. So, of course, I used a green cover sheet and broke it down as required so it wouldn't get kicked back to me. So on, what's the date e-filed? March 31st, 2026, at 9:17 p.m., I e-filed my petition for rehearing. Justin Serlick got a copy. He gets a copy of everything as required by law. That's protected due process, is a certificate of service. I believe even my children, Ariana and Tommy, everything I've been filing now that they're adults, their emails have been linked to the, what is it called? The courtesy copy. Courtesy copy by Illinois e-file. So my children have been getting copies of this as well. Whether or not they're reading it and opening it, I don't know, but they will never be able to come back and say, we didn't know anything about this. No, I was making sure you got copies because you're adults now and you have the right to know what's going on because your whole last 6 years of your life is a lie. I hate to say it. Ariana, Tommy, Bianca, and Charlie, the whole last 6 years since October 8th, 2020 has been a lie. You are living a lie. And I don't know how else to get this information to you other than using a podcast and my First Amendment right. Where's our lemon pound cake?
Yeah, I didn't get that set up yet. But
we need some lemon pound cake.
Expand a little bit just on that last statement you made. Explain to our viewers, because a lot of our viewers may not understand what you mean when you're telling your kids that the last 6 years have been a lie.
Yeah.
Explain that a little bit.
Well, everyone down to Elizabeth Tevis of Camelot Care has been lying to them. Every single person that has been coordinating and orchestrating this entire kidnapping, governmental kidnapping, since October 8th, 2020, where all 4 of my children were kidnapped from Kitty Cottage Daycare in Fox Lake. The caseworker, Jessica Lyman, I still have the text to this day. I saved all the texts because I've been building a U.S. constitutional civil rights case since the moment my children were kidnapped from Kitty Cottage Daycare. She did not have a court order. She did not have a badge of identification. She did not have a business card. She could not tell me who her supervisor was. And all of that is documented in text messages to her. All I had was her cell phone number, Jessica Lyman, supposedly of the Waukegan DCFS office, and literally is the person that kidnapped my children from Kitty Cottage Daycare. So everyone, including Jessica Lyman, has been lying to my children. Mary, Ira, and Justin Serlick have been lying to them since October 8th, 2020.
And we know that. What are some of the lies that we know you've been told
one specifically was the very last Zoom meeting I had with my daughter Bianca Serlick, December 6th of 2021. It was only 3 months after she was brought down here with her older and younger brothers, Tommy and Charlie. And Elizabeth Tevis was in that Zoom meeting where Bianca said to me, Grandma Mary told us that you gave us up for adoption in Illinois, and that's why we were brought down to Florida with Dad.
And
couldn't be further from the truth.
Absolutely no truth to that at all. There's nothing remotely close to that in any of the documentation.
Nope.
What you have in the documentation is Illinois DCF in their official reports basically saying, based on statements from Justin, that's how they're making all their decisions.
Right.
So your ex-husband, who you've divorced and you filed and
June
you were actively in
24th,
court against.
2013, I divorced him.
And the moment all of this started, you were already actively had an open family law case to modify that parenting case.
Not him.
And so he would have no reason to make anything up to benefit himself in the family law case?
None. None.
Silver bullet.
This is all because I refused to move the children down to Florida because he wanted to move to Florida to live with mommy and daddy in Port Orange, Florida during the pandemic because he caused us to lose our home. Yes, Justin Serlick caused us to lose our home. Yeah. How did he cause us to lose our home? He stopped paying his portion of the rent, and I couldn't afford to pay my portion and his portion.
And he never told you that he had stopped paying until the eviction notice was stapled to the
Nor
door.
did he ever pay me anything to store his property for years. I was storing his property in storage units. Never got a cent from him. So anyways, March 31st, 2026, I filed the petition for rehearing. And how this has to be set up is points. Point 1, point 2, point 3. So Pete, I want you to read just the basics of this, just to give them an idea of some of the points we were hitting on.
So, there's points, but then it starts with a preliminary statement. So maybe it's just best I read the quick preliminary statement.
Yes.
This court must distinguish between void and voidable judgments. A void judgment is one entered by a court without jurisdiction over the parties or subject matter, lacking inherent power to make the order. It is a nullity from the inception and may be attacked at any time, directly or collaterally. And then we have the case law that specifies that. A voidable judgment is one entered erroneously by a court having jurisdiction. So a voidable is one that the court does have jurisdiction, but it's erroneous judgment, and it is not subject to collateral attack, meaning in totality. A judgment rendered by a court which fails to acquire jurisdiction over the parties is void and may be attacked at any time. Because lack of valid service and notice, the April 27, 2022 order is void, not merely voidable. The court's failure to apply this critical distinction infected its entire analysis. And then we had, how many points did we have?
Quite a few.
12? 11, 12. Yeah, basic 12 points.
12 points of argument.
And here's the thing. We could have made this 20 or 30, but there's time limits.
Right.
So you
page limits and word limits as well.
So you have
page limits and word limits.
You have to get it, within the guidelines. Otherwise, you're one letter over, one word over,
read the conclusion.
They will throw it out. So
and if you're interested in reading all the rest of this, it will obviously be in the document in the order that we're discussing this in the podcast.
So
look for that Google Doc link.
In conclusion, and again, this is on Heather's motion for rehearing or petition for rehearing. The court misapprehended the nature of the petitioner's claim and the governing law. Petitioner sought relief from a void judgment under Section 2-140 or 2-1401F, not a new custody modification. The court resolved only a UCC JEA subject matter issue under McCormick. That was the case law I was mentioning previously. While failing to address the dispositive and independent issues of defective service, lack of personal jurisdiction, and denial of due process, defects that render the April 27, 2022 order void as a matter of law. As of March 31st, the respondent, Appellate Justin Derek Serlick of Daytona Beach, Florida, continues to use the April 27, 2022 three-page order as the basis for withholding any and all contact between mother Heather Bendel and the minor children. As a result, petitioner appellant has now lost 6 full years with her children. In practical effect, the three-page order has enabled the continued concealment of the children from their mother and has permitted ongoing abuse, neglect, and harm to continue unchecked. 2 of the 4 children have now reached adulthood, but the damage caused during these lost years cannot be undone. The record reflects grave concerns for the children's welfare. Florida police reports document Thomas Serlick's attempted suicide and Baker Act intervention in 2022, shortly after the entry of the April 27, 2022 order signed by Judge Marnie Slavin. The record also reflects extreme unexcused school absences and approximately 1.0 GPAs for 3 of the 4 children in Volusia County schools during the 4 years following their transfer from Illinois to Florida. This continues while the mother, Heather Bendel, is a public high school teacher in Orlando, Florida, responsible for over 150 minor children, yet has zero access to her own minor children due to this order. Petitioner appellant respectfully asks the court to make the lawful, just, and morally sound decision to protect the remaining minor children and place their best interests first. Vacating the April 27, 2022 order would not itself create a present custody modification. Petitioner petitioner appellant fully recognizes that any current custody determination or modification of physical custody must be properly pursued in the state of Florida.
Yeah. So that was filed March 31st.
And it took them, what, a week?
9 days later, April 9th, one page. The court has this day, April 9th, 2026, entered the following order in the above reference case. The petition for rehearing is denied.
Now
A modified Rule 23 order upon denial of the petition for rehearing is hereby filed this date and is accessible at www.illinoiscourts.gov. Kennedy, McLaren, Burkett, JJ.
So
Signed, Jeffrey Kaplan.
So one of the things people may be asking is why even ask for a rehearing?
Because you have to if you want to move it along.
So that's you have to
Exhaust everything.
Every option available to you. So here's ultimately what you've been doing. See, people might look at it from the outside and say, well, she's lost every case she's filed. That's not what's going on here. What's going on is you are going through the process to exhaust every remedy at the local and state level.
You have to exhaust everything at state before you go federal.
Because if
you have to go to tribunal, lower tribunal, you have to go through appellant, and then you have to go through Supreme Court. And then once you've done all three and exhausted everything at the state level, then you take it to federal court. Yeah. And I have actually had this confirmed by a law firm here in Orlando, Florida.
Because
they flat out confirmed with me, nope. If you file anything in federal before you've gone all the way through Supreme Court of the state, your federal case is going to be kicked back and dismissed.
Because what's going to happen is they're going to say, well, you could have appealed this and you chose not to appeal.
Right.
So,
this has been my strategy the whole time. The whole time this has been my strategy.
Ultimately with every denial of an appeal, all that's happening is they are moving
it along so I can go up.
They are moving everybody closer to being served
by U.S. Marshals.
Subpoenas by U.S. Marshals.
Yeah. And then after that one page signed by Jeffrey Kaplan, clerk of District 2 Court of Appeals in Elgin, Illinois, there is a modified upon denial of rehearing April 9th, 2026 for the order. And that says, and this was April 9th, so the same date as that one page from Kaplan, held the circuit court did not err in dismissing petitioner's pro se petition, which sought to vacate parenting order affecting the custody of her children, because the circuit court has subject matter and personal jurisdiction to enter the parenting order. No, they didn't. And it's not a parenting order. Further, no procedural errors were supported by the record. Affirmed. This is such bullshit. And they really should be embarrassed by pushing this out.
For them to say there was no procedural issues supported by the record literally means they did not look at the record, because there's
no certificate of service on it at all.
There was blatant due process stuff printed in ink.
Yep.
Or toner printer.
Yep.
Printer toner.
Yep. No. All right. So moving along to my 14-year-old daughter, Bianca Elizabeth Serlick in Volusia County Schools, is her quarter 3 report card. And so quarter 1 GPA, so this was in 2025, 2.0. Quarter 2 report card, 1.4285, so 1.43. Okay. Quarter 3 report card, 1.5714. Pete, what are all of her grades? Just read them out.
Pretty much
for quarter 3.
Quarter 3, D, D, C, B, D, D, C. Not good.
No A's, no B's, C's, and D's. Overall GPA is
not even. It's not a passing.
It's
GPA.
not a pass. Yeah.
Now here, I want to bring something.
So this is going to be scanned with all the rest of the documents, so everyone can see it. But my point being, this has been 3 years of this. So and this isn't just recent. This is the last 3 years.
I want to bring something up here, because we, online, Heather's gotten some pushback and criticism when she brings up her children's grades. So I want to bring some clarity to the situation. this is by no means your first choice. This is not anything you want to do. You have, as a mother of 4 children, who the little information that you get about your kids is that they are not thriving.
Right.
So as any good parent would do, you have literally gone through any and every possible option that you've been able to. You literally contacted the guidance counselors and assistant principals at all of the schools.
They won't talk to me. They won't even let me on the property to talk to people in person. I've literally been told not to come onto the property, which is literally illegal. And Volusia County schools are going to be sued by me in federal court. It's illegal. They can't do that.
The elementary school where Charlie was going, you actually were seeing him for lunches until Justin found out, and then Justin went back to the school and said, I don't want her to see him. So, that got shut down. So,
it's all illegal. So, Volusia County schools cannot block a parent, a biological, that's the key, biological parent. Cannot block a biological parent, according to Florida Supreme Court law, from speaking to their children's administrators and guidance counselors regarding their grades, attendance, and discipline.
Full rights to all school records.
Absolutely.
But it goes beyond that. So it wasn't, you literally went, to try to communicate directly with the schools, and you ended up getting shut down.
Yep.
You've gotten text messages from supposedly from your daughter and supposedly from one of her friends.
Allegedly.
You have filed police reports based on the content of those text messages.
Yeah. The very first episode of season 2 was talking about this.
You have filed Florida DCF reports as a mandate reporter based on content of messages you were sent. And
because Florida DCF does not see children's grades and attendance as neglect, which Tallahassee, that needs to change because that is absolutely neglect. Yeah. That is absolutely child abuse and neglect. I don't know who decided to leave that out when it comes to Florida DCF investigations, but education, attendance, and discipline in schools is absolutely something that investigators should be looking at when it comes to abuse and neglect.
And you've also brought up all of the issues of the kids' grades to the judge in your case here in Florida. And basically she said, I'm kind of concerned, but not really.
Yeah. That was Judge Sanders C. Upchurch in Daytona.
And so what
January
else?
8th of 2025, so...
I mean, it comes down to what else...
but even the judges in Daytona don't seem to care about your welfare.
It comes down to, again, as the kid's mother, you have gone through everything. I mean, you've literally asked multiple attorneys, what else should you do? And
I literally have a letter from my hired attorney, Rick Brown, who is insanely expensive. We ended up putting a shit ton of his retainer on credit card debt. He literally said, you currently have legal custody of your 17-year-old daughter, Ariana Serlick, and you absolutely have the right to go see your children on school property, go to the schools, work with the administration to get their grades up because their grades have been like this since 2023. Yeah. And in 2024, I had attorney Rick Brown of Daytona Beach write a letter for me to give to Volusia County schools stating mom has access to the kids on school property. Mom actually has legal custody of Ariana Serlick right now. And Ariana Serlick is literally skipping class and has a 1.0 GPA at Mainland High School. Right. So mom needs to work with the teachers and the administration on getting her grades up, which is literally why I was at Mainland, Ariana and Tommy. My attorney told me to go to Mainland. My attorney told me to go to Campbell Middle School. My attorney told me to go to Palm Terrace Elementary. So that was all done through the direction of my paid attorney, Rick Brown.
But it comes down to this, as the children's mom, you've been completely cut off from them, but you still are, the information you're getting, which is very limited. It's literally what you can see on the parent portal, so you can see their grades and
Bianca
attendance.
Currently,
and a few random messages that you've gotten that we can't even properly verify that they're actually coming from your kids, because
Right.
they're just text messages or emails.
Mary
that could come
Serlick and
from
Laura
anybody.
Stiles love to pretend to be my
so
children
the
on
reason-
social media. So
so
we
the-
have no idea who is what.
Ultimately, the reason why you bring things up like the kids' grades on the podcast and on your Facebook is because you don't know what else to do to try to get some help for them.
Pete, you've seen my children's report cards prior
have.
to 2020.
Yeah.
What did they look like?
They were basically straight A's when they were in Illinois, when you were their full custodial parent.
Fox Lake, Illinois, District 114. Straight A honor roll students.
Perfect attendance.
Ariana was in the National Junior Honor Society at Stanton Middle School. Tommy was getting ready to apply to be in NJHS as well. They literally have multiple years of perfect attendance certificates.
They were all in Scouts.
What were they doing in Scouts? You've seen their awards. You've seen their uniforms. Really impressive
getting
uniforms.
All of the merit badges.
Yep. Tommy had a goal to earn every single merit badge and reach Eagle Scout status. It's unfortunate to say that he never reached that goal because Illinois DCFS stole their life from them. Justin, Mary, and Ira Serlick stole their life from them. And that is 6 years of time my children will never get back. That is 6 years of time I will never get back. It is 6 years of lies they are living. They are literally living a lie in a fantasy world created by Justin, Mary, and Ira Serlick.
And here's the thing, like, so I've now been back up to your hometown in Illinois with you twice.
Mm-hmm.
I've met a bunch of your friends up there.
Mm-hmm.
And, you know, basically even, you know, all of your friends that I've met verify everything that you've told me.
Yeah.
Which is also verified by all the documents,
right,
and emails and text messages.
Several years of emails between my attorney, Thomas Hunter, and Oren Grappe, all the emails between Elizabeth Tevis, my attorneys, and myself. See, that's one thing that Justin, Mary, and Ira Serlick probably did not think about when concocting this insane lie and delusion they're living with my children, is that there are several years of emails with Camelot Care and my attorneys documenting my story. And all of those emails I still have.
Yeah.
And they will be provided to my children. And quite a few of them are actually in my court documents as exhibits already. But all the emails between Elizabeth Tevis and I absolutely show that Elizabeth Tevis was hiding my children from me. When DCFS is supposed to be about reunification, the whole time they were keeping my children from me to create a false narrative, a fictitious narrative, because they were planning on selling, literally selling like pieces of property, my children to the non-custodial parent, Justin Serlick.
Actually, even before that, they were planning on selling them into the foster system permanently.
Yeah.
And
if
adopting
Justin
them out.
Serlick didn't exist, my children would have been sold off and adopted out.
You did not put your kids
because that's where they make their money with Title 4E.
You did not put your children up for adoption.
Nope.
But they were the
Absolutely
Illinois
not.
DCF system.
I would never ever do that.
The Illinois DCF system was pushing them that way.
Yep.
And had Justin and his attorney at the time not filed what they filed in the juvenile dependency court, getting the kids sent to Florida. See, once the kids got sent to Florida, then they couldn't do anything.
Right.
But had the kids stayed in Illinois,
they would have
Illinois
sold them.
DCF
They would have adopted them
out
out through federal Title 4E funding, which is
money.
foster care and adoption kickbacks that the federal government give to the state.
It's crazy how much, I mean, how much we have learned in the past year.
Yeah. Well, Connie regularly is the specialist when it comes to Title 4E.
Yeah.
Like, she, as an attorney, has been working that side of family court for decades. And now she's a massive whistleblower in Washington, D.C. to Title 4E. What's the word I want to use? Fraud. Yeah. Title 4E fraud amongst all 50 states. Now, Mark Ludwig out of St. Louis, Missouri specializes in Title 4D fraud. And
Which is tied to child support.
Support. So I'm dealing with Title IV D fraud. And when my kids were in the Illinois system, they were Title IV E fraud. So this is all fraud upon the court through federal funding, which is why hundreds, if not thousands of us at this point are advocating for Title IV reform across the board in Washington, D.C.
I mean, there's so many problems.
So think the Minnesota Child Care Assistance Program. CCAP is what it's known as, Child Care Assistance Program. Minnesota just got busted for that. That is part of Title IV fraud. So it's only a matter of time. It's starting to be exposed. And the only reason it hasn't been exposed prior to now is because of social media. Until social media really came along, it was behind closed doors, and no one really had a way to talk about it across the globe.
And the judges do what, was it Morozen did to you? Put a gag order on you in a
unconstitutional gag order. So I couldn't say a word on the internet. I couldn't even talk to my own father. As soon as he put that gag order on me, October 13th of 2020, I was literally silenced in fear that if I even spoke to my father about what was happening to his grandchildren, I would be held in contempt of court under that gag order, which is absolutely illegal in family court.
Every judge at every level of court, other than criminal court with jury trials, any judge that issues a gag order should just have their ass dragged to federal prison for constitutional First Amendment violations.
First Amendment. Lemon pound cake, everyone.
Yeah. If you have not seen it, I know it was all over the news. It was while we were up there.
And
in
he
Illinois.
was just here in DeLand. I really wanted to go to his concert in DeLand.
Look up the Afro Man case out of Ohio, where a bunch of police stormed his house. He, had a home security system, recorded them in there, stealing his money, eating his food, breaking his stuff. And, when it was all said and done, he used that video to make some music videos. He's a artist, music artist. He's a bit of a comedian. If you listen to his songs,
he's also into politics.
And these local sheriff's deputies, they got a stick up their ass and thought they could go after some easy money and tried to file a lawsuit against him. But the jury of his peers said,
First Amendment.
Oh no. No.
First Amendment.
He gets to say whatever he wants. Go as
freedom of speech, baby.
as he said, he gets to kick a can in his own backyard.
Yep. So that's it for Florida District 2 or Florida District 5 Court of Appeals and Illinois District 2 Court of Appeals. Next steps are Florida Supreme Court, Illinois Supreme Court, and federal court. So as soon as I'm done,
and now you're also
utilizing Supreme Court
refiling in Florida Circuit 7 as well, because you're restarting there.
Yep.
See, that's the thing here that Justin and his parents don't seem to understand. First of all, you're not. I want to make this clear. You are not filing to be malicious.
Nope.
But if he doesn't let you see your children, you will keep him in court for the rest of his natural life.
Yep. If you're going to continue stealing $1,785 a month of my teacher's salary while holding my children hostage and not even letting me speak to them on the phone, I will continue taking you to court. And
is your legal right.
You might want to research U.S. District Court, because when those U.S. Marshals show up, don't be surprised.
So we have to get back to this. So circling back, this is kind of the fun part of the story. So we've covered the documents and on the appeal, but there's a little more. So we went on a spring break trip up to Chicago. The day District 2 issued that,
we were at the
U.S.
Chicago
federal courthouse in downtown Chicago, getting some information from the clerk's office.
I still have to upload those 2 clips from me in front of the U.S. District courthouse in downtown Chicago. And we didn't cover that. So we had stopped at Illinois District 2 Court of Appeals.
That's what I was getting to next.
Literally one day after they filed this affirmation.
So they definitely were not expecting Heather to show up in person less than 24 hours after they issued.
I was already in Chicago, and I was already planning on going there.
They had there's signs in it that they used some AI to write some of it.
Oh, yes. But the kicker was I showed up to Illinois District 2 Court of Appeals in Elgin, Illinois, Kane County, in person at 11:45 a.m. on a Thursday.
And the door was locked.
And the door to the courthouse is locked.
The main entrance door, front door to the courthouse, locked.
And when I asked Circuit Clerk Jeff Kaplan why the door was locked.
Now, let me... After knocking on the door and trying to pull on it, you had turned and were starting to walk away. And then some security guard comes in and says, I think you're in the wrong spot. You want to go to the circuit court. And you're like, no.
I'm definitely at the right courthouse. But no, on the phone, Jeffrey Kaplan's explanation for his door being locked is for safety reasons. Safety. They are concerned about their safety in a court of appeals while they're trampling my constitutional rights and my Illinois constitutional rights and aiding and abetting my children being neglected and abused. So they're worried about their safety in Elgin, Illinois, but don't give a flying about my children's safety. So on that note, we're going to end the podcast episode here. The next episode will be in a few weeks. We have to get busy with this PLA to Illinois Supreme Court because I did get a written opinion in Illinois District 2 Court of Appeals. So my next step is a petition for leave for appeal in Illinois Supreme Court. So Illinois Supreme Court, here we come. Then I need to decide what extraordinary writ I'm going to file in Florida Supreme Court next. And then when Supreme Courts don't do anything to protect my children, here comes U.S. District Court in Orlando and downtown Chicago. Yep. So on that note, have a great night, everyone. And I hope everyone has a great night. Bye-bye.
The content of this episode is for educational and advocacy purposes only. All statements made reflect documented filings and communications received by Heather Bendel and the Justice for the Serlick Children team. We encourage all listeners to form their own conclusions based on the evidence presented. No accusations are made without supporting documentation, and all persons are presumed innocent unless proven otherwise through due process.
Shadows find the family court. They bury the truth, they cut the support. Corruption thrives where the silence stays. But we're lighting a fire to burn down the maze. We are the voice for the voiceless. We are the voice for the voiceless. This is the Justice for the Serlick Children podcast.